This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to explain why GEICO has taken a bite out of fraud and why no-fault insurance, at least in New York, seems to be a formula for insurance fraud perpetrators. GEICO, as a proactive victim of insurance fraud, sues Jean-Pierre Barakat, MD, et al., alleging that the defendants had defrauded GEICO in violation of the Racketeering, Influenced, and Corrupt Organization Act, RICO, 18 U.S.C. 1962. By submitting hundreds of fraudulent bills for no-fault insurance charges. Plaintiffs also alleged common law fraud and unjust enrichment and seek a declaratory judgment as to all pending bills. In GEICO v. Jean-Pierre Barakat et al., the United States District Court for the Eastern District of New York on January 2, 2024, provided an injunction on behalf of GEICO. GEICO was faced with at least 43 allegedly fraudulent no-fault claims from healthcare providers, and it moved for preliminary injunction to stay all 43 pending no-fault insurance collection arbitrations commenced against GEICO by or on behalf of the defendant. In New York, an insurer is required to provide certain no-fault insurance benefits to the individuals that they insure. No-fault benefits cover up to $50,000 of necessary health care expenses that result from automobile accidents. These benefits are provided to ensure that injured victims of motor vehicle accidents have an efficient mechanism to pay for and receive the health care services that they need. Insurers are only given 30 days to review and investigate claims before paying those claims to avoid the risk of penalty for denying or delaying a claim. GEICO alleged that in 2021, Defendant Barakat was recruited by the John Doe defendants to participate in a complex fraudulent insurance scheme to bill GEICO and other New York automobile insurers for medically unnecessary, experimental, and otherwise non-reimbursable services. Based on the arrangement, Barakat would receive a periodic payment in exchange for the use of his name, license, and the tax identification number of the Barakat practices. Defendants would perform medically unnecessary, high billing value procedures. Between February 15 of 2021 and March 3 of 2022, Barakat and the John Doe defendants used Defendant Patriot Medical to bill GEICO and other New York automobile insurers for an experimental treatment called ESWT. Moreover, defendants submitted bills seeking more than $106,000 from GEICO, spread across 43 no-fault individual arbitration proceedings pending before the American Arbitration Association at the time the motion was filed. In support of its fraud claims, GEICO has submitted a representative sample chart totaling 1,371 entries of allegedly fraudulent and no-fault claims submitted by the Barakat practices. GEICO asserted that it has paid at least $183,000 to the Barakat practices in no-fault claims. Now, for an injunction, there must be a showing of irreparable harm as the single most important prerequisite for the issuance of a preliminary injunction, and the moving party must show that the injury is likely before the other requirements for an injunction are considered. The harm must be shown to be an actual and imminent, not remote or speculative. The USDC noted that the courts in this district have found in analogous cases that irreparable harm occurred when an insurer is required to waste time defending numerous no-fault actions when the same proceedings could be resolved globally in a single pending declaratory judgment action. There are currently 43 pending arbitrations that run the risk of inconsistent judgments. GEICO has shown that money damages may not be available if the defendants are to prevail. This is sufficient to establish irreparable harm. There is no indication that granting the stay will harm the public interest. To the contrary, GEICO asserts that the injunctive relief would serve the public policy against no-fault insurance fraud. Plaintiffs have alleged irreparable harm absence of stay, that there are serious questions going to the merits of the case, and that the balance of hardships tip in their favor, and that a stay would not harm the public interest. The court, therefore, granted plaintiffs' motion for a preliminary injunction, and for the foregoing reasons, GEICO's motion to stay all pending no-fault insurance collection arbitrations by or on behalf of the defendants, waive their obligation to post security, so that GEICO can go forward with its actions against the Barakat defendants. In my opinion, GEICO must be honored for its proactive conduct against fraud perpetrators, since it appears the state of New York is not concerned about fraud against insurers and will not prosecute the fraudsters. Using RICO not only will allow GEICO to work to defeat the fraudulent claims, but will take the profit out of the crime by forcing the fraudsters to pay the insurers for their fraudulent conduct. Other insurers facing the same fraud should jump into the lawsuit with GEICO to make the fraud perpetrators understand that they will lose their criminal profits and may find they will be paying the insurers, in addition, a great deal of money under the RICO law. This video is adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog at that site, and you will receive notice of all blog postings, usually 5, sometimes 6 a week, and access to the more than 4,700 blog postings. You can also subscribe to the free videos on rumble.com and youtube.com, and if you do, I'd appreciate it if you click on the thumbs up button on Rumble and the like button on YouTube. You can also, if you're interested in receiving more detail about insurance, insurance law, insurance fraud, and insurance claims, for a very small fee, subscribe to my Substack publication. Thank you for your attention.